Start. Para. Perusal of covenants of the agreement dated 28 October 1977, executed in their capacity as promoters with flat purchasers, clearly show obligation on the part of the promoters to convey land at measuring 1583.46 square meters in favor of the society formed by the flat purchasers. The promoters ought to have fulfilled the said obligation by executing conveyance under section 11 in bracket 1 in favor of the society, since there is admitted failure on the part of the promoters to discharge their obligation under section 11 in bracket 1. The competent authority ought to have done what the promoter has failed to do under section 11 in bracket 1. The statutory scheme of MOFA is such that the competent authority exercising jurisdiction under section 11 thereof is not supposed to institute an inquiry into disputes relating to title. If there is a promoter who has constructed a building and sold flats therein, there is an obligation imposed on the promoter to convey the land on which the building is constructed in favor of the society. The dispute relating to promoter's title in the land is something which is outside the scope of enquiry under section 11 of MOFA. If any person claims that promoter is not the owner or not the exclusive owner in respect of the land on which building is constructed, and if such person claims ownership in such land, it is for that person to institute civil suit and establish his rights to the land in question. Pendency of such title disputes cannot be a ground for not conveying land under section 11 of the competent authority. This is especially true when there is no fetter on grant such conveyance in the form of any injunction granted by the civil court. In the present case, there was no reason for the competent authority to injunct itself from performing its statutory functions under section 11 of the MOFA in absence of any injunction granted to that effect by the civil court. In my view, therefore, the competent authority has failed to perform its statutory obligations under section 3, 4 and 5 of MOFA and has committed palpable error in entertaining and considering title disputes between the parties while rejecting society's application for deemed conveyance. In 2012, the competent authority had in fact conducted inquiry into title disputes and had held to be the owner in respect of the land in question. That order has already been set aside by this court in the fresh application filed by the society, though merits of title dispute this time are skirted by the competent authority. Pendency of title dispute is used as a rule for not performing statutory functions under section 11 of the MOFA. The entire approach of the competent authority, to my mind, appears to be faulty. Para. Thus, mere pendency of title suit between promoter and other persons claiming a right or share in the land sought to be conveyed cannot be a ground for avoiding performance of statutory duty by the competent authority under section 11 in bracket 3 of the MOFA. In the present case as well, certificate of unilateral deemed conveyance would obviously be subject to the decree that would be passed in suit number 9750 of 1977. Issuance of such certificate would not impinge upon rights and contentions of any of the parties in the said suit. He has submitted that society had attempted to intervene in the suit, but its intervention application was opposed by plaintiffs therein, and the society is not permitted to participate in the decision of the suit. He would therefore submit that decree passed in the suit would not be binding on the society. This is something which the plaintiffs need to take into consideration. So far as writ petition number 1421 of 2024 is concerned, it would be sufficient to clarify that issuance of certificate of unilateral deemed conveyance would be subject to the decree passed by the City Civil Court in suit number 9750 of 1977.